As regards Clause 9, Clause 9A, this clause is intended to amend the provision in the current Constitution that provides for disqualifying a candidate based on the decision of the Constitutional Court rather than being based on the provisions of the Constitution as determined by the Constitutional Court. So there is no objection there. Clause 9B of the bill, NIPA has no objection to the same. This clause intends to eliminate the need for holding by-elections whenever a vacancy arises in the National Assembly for a member of Parliament, which has proved to be costly to the nation, and public outcry has generally been that by-elections are a huge burden to the nation's treasury. With regard to Clause 9C again, NIPA agrees to the provision as the clause merely intends to provide that a person elected as member of Parliament by a political party following a vacancy shall serve for the unexpired term of Parliament. In addition to that, with regard to Clause 9C, where there is no objection, the clause provides that a person elected as member of Parliament by a political party following a vacancy shall meet the requirements specified under Article 70 for eligibility to be elected as a member of Parliament. There is no objection to that. The said clause also provides that a by-election shall not be held within the 180-day period preceding a general election, even if a vacancy arises. We don't object to that. The last of Clause C is that the Electoral Commission shall by regulations set the date and time for submission of the name of the person elected by a political party following a vacancy, as well as guide on the time frame for the completion of the same. We don't object to that provision. With regard to Clause 10, there is no objection. This clause, on the basis that it is the obligation of the courts to not only to hear but also determine matters. This is just one of the lacunas in our Constitution, which is being put clearly here. Then Clause 11, NIPA has no objection to Clause 11 as it relates to the term of Parliament, as the clause is changing the commencement of the term of Parliament from the current provision, which provides for commencement of the term when members of Parliament are sworn into office. It's being changed to the first sitting of the National Assembly after a general election. We have no objection to that provision. NIPA is of a view that it is just proper that the term of Parliament begins from the first sitting of Parliament rather than from when the members of Parliament are sworn into office. In addition to that, as regards Clause 11, NIPA has no objection as it relates to extending the term of Parliament for a period not exceeding 12 months when the Republic is at war, as the situation may not favor the holding of elections in those circumstances. Furthermore, in relation to Clause 11, NIPA does not object as it relates to the dissolution of Parliament a day preceding the date of the general elections. This is what would make a complete term of 5 years. The current provision in the Zambian Constitution providing for the dissolution of Parliament 90 days before the next general elections does not give Parliament a complete 5-year term as provided under the same Constitution. Further, in Clause 11, NIPA does not object as it relates to providing for Parliament not sitting or conducting any business 90 days before the holding of the next general elections. NIPA is of a view that this is so in that the 90 days is meant to provide the space for members of Parliament to campaign for the next general elections. Furthermore, as regards the same Clause 11, relating to the President dissolving Parliament in circumstances where the Executive cannot effectively govern the Republic, Due to the failure of the National Assembly to objectively and reasonably carry out its legislative function, NIPA does not object, and the view of NIPA is that this provision exists in the current constitution and is meant to ensure that Parliament objectively and reasonably carries out its legislative function without disrupting the running of government. Further, the same clause 11, NIPA does not object as it relates to the President informing the public and referring the matter to the Constitutional Court concerning the dissolution of Parliament in circumstances when the National Assembly is dissolved by the President due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. Still, on clause 11, NIPA has no objection as it relates to the Constitutional Court hearing and determining within 7 days of receipt of the matter concerning the dissolution of Parliament in circumstances where the National Assembly is dissolved by the President due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. Furthermore, in relation to clause 11, NIPA does not object in terms of the clause providing for the Constitutional Court deciding and informing the President to dissolve the Parliament in circumstances where the President decides to dissolve the National Assembly due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. NIPA is of a view that this is so in that the determination as to whether Parliament be dissolved for failure to objectively and reasonably carry out its legislative function shall be made by the Constitutional Court. NIPA also does not object.
Order witness, can you be a bit loud in your submission?
NIPA also does not object with regard to the said clause 11, providing for the President continuing to perform the executive functions until the President-elect assumes office in circumstances where the National Assembly is dissolved by the President due to the failure of the National Assembly to objective and reasonably carry out its legislative function. NIPA also does not object to clause 11 in which as it provides for the holding of elections within 90 days of the dissolution of Parliament in circumstances where the National Assembly is dissolved by the President due to the failure of the National Assembly to objectively and reasonably carry out its legislative function. Furthermore, as regards clause 11, there is no objection, NIPA has no objection as it relates to the President recalling the National Assembly that was dissolved before a general election or a National Assembly that was suspended in circumstances of war, state of emergency, or threatened state of public emergency. NIPA is of a view that this is so in that in the stated circumstances, certain government decisions may need the approval of the National Assembly. Hence, they need to recall the National Assembly that was dissolved or suspended. Finally, as regards clause 11, NIPA has no objection in terms of the clause providing for the President proroguing Parliament in consultation with the Speaker. NIPA is of a view that this is so in that there are circumstances when it is necessary to prorogue Parliament, such as the threatened public health situation. Clause 12, there is no objection from NIPA. This is justified, the clause, as it is the obligation of the courts to not only hear but also determine matters. Clause 13, NIPA does not object to clause 13, which provides that the office of minister shall become vacant 90 days before a general election. NIPA is of a view that this provision is justified in that it is in line with the current constitution, which provides for the 90 days before general elections as the campaign period. This will ensure that ministers will not be in office and thereby use public resources to their advantage during the campaign period. Clause 14, NIPA has no objection as it provides clause 14A of the bill that provides that the office of provincial minister shall become vacant 90 days before a general election. Again, NIPA's position is that this provision is justified in that it is in line with the current constitution, which provides for the 90 days before general elections as the campaign period. This will ensure that provincial ministers will not be in office and thereby use public resources to their advantage during the campaign period. NIPA also has no objection as regards to clause 14b that provides for renumbering of clauses 3 of Article 117 as clause 4. With regard to clause 15, NIPA does not object to that clause again that provides for the insertion of the word electoral immediately before the word boundaries. This provision is justified as it clarifies that the boundaries are simply for electoral purposes. With regard to clause 16, NIPA does not object to the same. The provision provides for the deletion of the figure 47, that is Article 47.3, and the substitution thereof of the figure 47.4. NIPA also has no objection to clause 16b relating to the inclusion of a member of parliament into the council. This provision is justified as it intends to include members of parliament into the council, which is not the case under the current constitution. NIPA also has no objection to clause 16b relating to the renumbering of paragraphs B and C as paragraph C and D respectively. NIPA has no objection to clause 16c providing that the term of a council shall be 5 years commencing from the day of the first sitting of a council after a general election and ending on the day parliament is dissolved. This is just proper. It is NIPA's view that it is just proper that the term of a council should begin from the first sitting of the council rather than from when the councillors are sworn into office. NIPA has no objection to clause 16d providing that a council shall not sit or conduct any business 90 days before the holding of the next general election. This provision is justified in that the 90 days is meant to provide space for mayors, council chairpersons and councillors to campaign for the next general elections, as it is the case with members of parliament. Then clause 17, NIPA has no objection to it as it provides for the eligibility for election of mayor and council chairperson. This is because the current constitution does not provide for the eligibility for mayor and council chairperson. In addition, the proposed eligibility criteria is the same as applies to members of parliament. So NIPA does not object to that. Then still in clause 7, NIPA does not object in terms of where it provides for the election of a mayor or council chairperson directly in accordance with Article 47.4 of the current constitution, which provides for the election to be conducted during elections for councillors as prescribed. Also, NIPA does not object to clause 17 where it provides for the election of a deputy mayor and deputy council chairperson by councillors from amongst themselves. NIPA's view is that this is what is provided in the current constitution and it does not raise any contention. Clause 18, NIPA has no objection to clause 18 that provides for filling of a vacancy in the office of mayor, council chairperson or councillor by a political party that sponsored the mayor, council chairperson or councillor. NIPA's view is that this clause is intended to eliminate the need for holding of by-elections whenever a vacancy arises in the office of mayor, council chairperson or councillor. This has proved to be costly to the nation, and public outcry has generally been that by-elections are a huge drain on the country's treasury. Still on clause 18, NIPA does not object as far as the clause provides that a person elected as mayor, council chairperson or councillor by a political party following a vacancy shall serve for the unexpired term of a council. Furthermore, as regards clause 18, NIPA does not object as far as it provides that a person elected as councillor by a political party following a vacancy shall meet the requirements specified for eligibility to be elected as councillor under Article 153(4) of the current Constitution. NIPA does not also object to Clause 18 insofar as it provides that a person elected as mayor or council chairperson by a political party following a vacancy shall meet the requirements specified for eligibility to be elected as mayor or council chairperson under Article 154(2). NIPA also does not object to Clause 18 as far as it provides that an election shall not be held within the 180-day period preceding a general election, even if a vacancy arises in the office of mayor, council chairperson, or councillor. This is the proposed position in relation to members of parliament. NIPA also has no objection to Clause 18 as it provides Article 18, where it provides that the Electoral Commission shall by regulations set the date and time for submission of the name of the person elected by a political party following a vacancy in the office of mayor, council chairperson, or councillor. Finally, with regards to Clause 18, NIPA has no objection also as far as where it provides that the Electoral Commission shall by regulations guide on the time frame for the completion of the process relating to the setting of the date and time for submission of the name of the person elected by a political party following a vacancy in the office of mayor, council chairperson, or councillor. In relation to Clause 19, NIPA has no objection to Clause 19 providing for the insertion of the words "and determined" immediately after the word "head." This is showing that it is the obligation of the court not only to hear but also determine matters. In Clause 20, NIPA does not object to the clause where it provides for the deletion of the word 10 and the substitution thereof of the word 5 immediately before the word years. This provision is meant to reduce the qualification for appointment as secretary to the cabinet in terms of experience from 10 years experience as permanent secretary or equivalent rank to 5 years experience as permanent secretary or equivalent rank. NIPA is of a view that the requirement for 10 years experience as permanent secretary reduces the availability of persons qualified to be appointed as secretary to the cabinet. With regard to Clause 21, NIPA does not object. The clause provides for the deletion of paragraph B of Article 178(1) of the current Constitution and renumbering of paragraph C and D as paragraph B and C respectively. This provision is, NIPA is of a view that this provision is justified as the Office of Attorney General is not a political office and therefore should not cease automatically upon a new president assuming office. NIPA has no, with regard to Clause 22, NIPA has no objection to Clause 22 providing for the deletion of paragraph B of Article 179(4) of the current Constitution and renumbering of paragraphs C and D as paragraphs B and C respectively. NIPA again is of the view that this provision is justified as the Office of Solicitor General, just like that of Attorney General, is not a political office and therefore should not cease automatically upon a new president assuming office. As regard the last clause, which is Clause 23, NIPA has no objection to Clause 23, providing for the definitions as provided. These are the submissions, Chair, by NIPA. Thank you.
Thank you, witness. Honorable members, that's the submission from National Institute of Public Administration, School of Law. We may begin to interact with them. Honorable Banda, then Honorable Kambita, in that order.
Thank you, Chair, and thanks so much, witness, for your submission. It seems you have got no objection to all the clauses in this bill. Now, there are some concerns from the public out there who are saying this bill is illegal. In your view, where do you think it has lost its understanding? I thank you. I submit.
Just for guidance, Honorable Member, we may not discuss the speculation in the public, but the bill is rightfully before Parliament. Nonetheless, Honorable Kambita.
Thank you very much, Chairperson. National Institute of Public Administration, I refer you to your submission on clause 16, which speaks to the term of office. Is it clause 16 which speaks to the term of office for National Assembly or members of Parliament? Kindly help me, honorable members. 16? Yes, on page 8. So my question, in asking my question, I want to refer you to also the act itself, I mean the bill. And the provision in the bill I think we start with 11, which speaks to the term of Parliament, and term of office of a member of Parliament shall be 5 years, commencing from the date of the first sitting of Parliament after a general election. I would like you to take note of the phrase first sitting of Parliament. Traditionally, the first sitting of Parliament happens, I think, approximately a month and a few days from the date of election, effectively reducing the period by a month or so from the 5 years. So I would like you to reconcile the consistency of the phrase shall be 5 years, and this is the Constitution we are dealing with, which also, if you read Article 1 of the Constitution, emphasizes its supremacy to the fact that there shouldn't be ambiguity or inconsistency within the Constitution itself. So I'd like you to suggest how we can probably put the right wording to ensure that we maintain the 5 years. Not only that, traditionally as well, not only do we start counting from the date when members are elected, but in the Constitution we want it to be written that from the date the Member of Parliament is sworn in. If we start from the date when the Member of Parliament is sworn in, then effectively will be inconsistent with the 5 years term. The same applies to the local government elected officials. So how do you suggest that we should cure this? I've seen even the previous Constitution 2016, Amendment Act number 2 of 2016, the wording is similar like that, and there is that inconsistency between the 5 years and the date of the first sitting. First sitting effectively knocks off from the 5 years. So how do you suggest that we should be consistent with the 5-year term? I submit.
Honorable Kandafula.
Thank you, Chair. I think it's sort of like, I think I can also as well say like wording on clause 18. When you talked of a political party to fill in the vacancy in case of any eventuality, Now, when you talk of voting, I don't know if we can call it an election, but otherwise, from what you have tabulated, can't we probably maybe remove a person who is elected by a political party to a person who has been appointed? Because when it comes to election, I think it should be very broad, where even those other opposing people can at times change, because even within the same party, there are factions. I submit.
Witness, you can respond to the 3 questions from the honorable members.
Okay.
Thank you very much, Chair. I think my colleague will start first.
Just guidance from the chairperson. There was a question that was based on the public. Is it still? Yes. Can we still respond to it?
No.
Yes.
No, you can respond to the 2 from Honorable Kambita and Honorable Kandafula.
Okay, so maybe let me start with from Honorable. Yeah, I think it is based on the election of a member of Parliament by a political party. I mean, to avoid, that is actually to avoid by-elections, isn't it? Okay. So where the honorable has a problem is the word elect instead of appoint, because what is provided for in the bill is political parties shall elect. So that is actually what, for me, I think that is more appropriate than appoint. Because if I look at that particular provision, I'm of a view that there will be an enabling probably act or statutory instrument or regulation to provide how such an election shall be carried out. Because in whichever way we look at it, expenses relating to the filling of a vacancy, relating to which occurs after maybe death and so on, the expenses will always be there, because that's what democracy is all about. But I want to believe there will be, it is my view that there will be probably an SI or regulations that will provide how this will actually be done within the structures of a party. I can give an example. I think political parties, they usually know how they do it during nominations. I'm just giving an example. Because really, if we just leave it to political party shall appoint, how? Whichever way we look at it, I feel that the Electoral Commission will still be involved in the election of a member of parliament by a political party within the structures of a political party. That in itself will reduce the expenses that relate to the filling of a vacancy, because currently, of course, we know the expenses that relate to by-elections. I have actually, my view is that there will be regulations that will provide it, that will guide on how parties will be able to fill such a vacancy. Because if you say appoint, maybe what if I mean, these structures within political parties differ. You find sometimes, what if the appointment is just by the top, where maybe only 4 people sit and actually propose a name? So there should be some resemblance of democracy that takes place within the structures of the party. I think that really will be actually probably be guided by prescribed by regulations also. So that is actually my opinion on the same.
I also wanted to add to say appointed. I wanted to add, Chair, that appointment sounds undemocratic, like my colleague has said, because we know that political parties, when they select their candidate for adoption, when they are adopted for elections, there is a process that is followed. So we believe that in that same vein, even if there is no law, and we don't have a law on political parties, structure, governance, and everything, so even if there is no law in place to that effect, but the same processes which are democratic should be used. than appointing someone, because this will be a situation where someone doesn't even know the constituents, and because he's a nephew or a son to someone, then they say, no, the people of so and so, this is your MP, and there are no elections. The moment you're appointed, you are the MP. So in the constitution, if we say election, it would be easy even to challenge if the process was not democratic than appointment. The appointment sounds more, it's not democratic. Thank you.
The one for Honorable Kambita. Honorable Kambita.
I think what I meant to refer to is clause 11 and clause 16. Clause 11 and clause 16.
On the same question, I understood the question.
You understood the question,
yes,
right?
Okay. The question relates to the fact that we have elections in August, and then Parliament only, the first sitting comes in September. But by then, so the question is, how does it clock 1 year? Because it means that the MP must have been MP from September of the election year until September the other year after elections. Maybe the one way to circumvent it is maybe to say now Parliament cannot exist after general elections, to say the MP should continue into office until the first sitting of the of Parliament after the general election.
Can I add maybe something?
Can help you,
Yeah.
Director. Yeah.
I think Honorable Kambita, actually your question, actually it is quite very difficult to address on the basis that we have a fixed date when elections are held, actually August, and this is actually the problem also regarding the current constitution. If you look at the term, it is not 5 years. And actually this particular bill tries to resolve the problem by actually providing that Parliament shall be dissolved a day before, MPs will remain actually a day before the general election, isn't it? Yes, so it's actually what this current bill is trying to resolve is actually the question that you have asked. But it may not be resolved fully. Yeah, it's because we have a fixed date when elections are held.
Question, Honorable Kambita. Okay, switch off your mic.
Would it be your considered view then, because I think what is bringing the problem in this particular article or in these separate articles is tying in one sentence the sitting of Parliament and the term. Why don't we separate the two, the term and the sitting, the office of the member of Parliament? Why don't we tie it to the election, from the time the member of Parliament is elected to the time another one is elected? Because that resolves the 5-year problem, without which we will still have a gap, either at the end or at the beginning. I submit. What do you think?
Honorable Mngandu. It's the same question?
No, it's a new question.
Okay.
Clause 3. Clause 3 on page 3. You have said the last. Yes. Your last paragraph. In addition, NIP has no objection to the provision of clause 3 intended to put a time frame within which a person is allowed to defect from one political party and become an independent candidate. This time frame is 2 months before the date of nomination. Now my point of clarification, this date of nomination is determined by the Electoral Commission of Zambia and it's not fixed. What if the Electoral Commission of Zambia, since the wording of this clause says 2 months before, what if the Electoral Commission of Zambia sets the nomination date 30 or 54 days before the general election? What happens to the independent candidate that would want to contest on a political party? And why put the restriction? I submit.
Yeah, you can, because the one from Honorable Kambita was just a comment. So, Honorable Anakoka.
Thank you, Chair. The proposed amendments to Article 52, which I think in your presentation is, you are identifying it as under Clause 4. In relation to what happens, one, if a candidate withdraws. Currently, in the Constitution, the elections are automatically cancelled. But now, Bill 7 is proposing that this election should go ahead. Have you applied your thoughts to a situation where a candidate withdraws too close to the holding of elections, such that even if they withdraw, it's not practical for ECZ to remove their name and face from the ballot paper? So the person has withdrawn, but the election will be held with their face and details on the ballot. If you have applied your thoughts to that, how is it a desirable situation? If not, any ideas of how that can be resolved? The second one is, in the case of death, where we are saying the elections should be cancelled, we maintain the status quo. And it must be held within 30 days after calling of fresh nominations. The proposed amendment does not address the question of how soon should this election be called. It just says 30 days after you call for elections. But it's open as to, after cancelling elections, do you call these elections within 30 days also, within 90 days? And a sub-question to that one is, if a period is to be included, a time limit, should it be the same for presidential elections as for parliamentary elections, given that the preparations for the two are quite different? Thank you, Chair.
I'd like to respond to 3 questions, 1 from Honorable Mngandu, 2 from Honorable Anakoka.
The question to do with, thank you very much, Chair. The question to do with the independent candidates. Our understanding of the provision is that, unless I'm guided, is that it relates to a candidate who belongs to a political party and now defects to become an independent. I heard the question was like put the other way around. Maybe I seek clarity on the same.
It's not that I'd put it the other way around. What I was trying to clarify is the 2 months resignation requirement. We have a date before the date of nominations, and this date of nomination is not prescribed. It's determined by the Electoral Commission of Zambia. What if we put it this way, where the requirement is 2 months before the date of nominations? Then the Electoral Commission of Zambia puts the date of nomination 1 month, 28 days. Don't you think it would defranchise those that would want, who have been left on a political party and would want to contest as independents? How fair do you think this 2 months requirement to an unknown date is? I submit.
Okay, I think the question is valid. We have taken note of I think the concerns raised by the Honorable is that at least the date of election is fixed, so the 2 months can easily be determined. But the nomination is actually set by the Electoral Commission of Zambia. So meaning anyone who is probably not adopted by the political party may be at the mercy of the Electoral Commission of Zambia, depending on the date that is actually picked for nominations, isn't it? Yeah, it's valid. We'll take that one into account. Probably we may not provide a response right away.
Can respond the other two from Honorable Anakoka.
Yeah, the Honorable has raised something that I never thought of. Really, concerning the withdrawal, resignation of a candidate before the holding of elections, isn't it? Yeah, I think if I understood the questions, that what if the resignation is just a few days, and you gave an example of 2 days before the elections, meaning the Electoral Commission of Zambia may not have ample time to remove the candidate that has resigned from the ballot, isn't it? Director.
It was just going through my mind. Somewhere I read about the Americans, where they have when such a situation arises. I remember when there were those elections, Kamala Harris, and there's an analysis that I read where they were saying when things have reached this stage, they can't remove the name from the ballot, but it's like they have a provision which provides, now that is the alternative that I can't recall properly, to say that person, even if the person wins, people vote for the person, but they will not be the winner. They have a diversion somehow, but I can't recall that diversion. I remember it intrigued my mind to say, okay, yeah, in that regard. But like my colleague has said, maybe that is something we can bring back again in shortest possible time.
Because what I see here is what the current constitution is trying to address. It's actually the chaos that can be created by perpetual resignation. And of course, we may see situations as this constitution is addressing lacunas in this current constitution. It's definitely to not really be 100% perfect. And this is why you find that actually certain provisions in this constitution shall be actually defects that may arise can only be cured by regulations of statutory instruments. But we are looking at really what is being cured. As much as there is actually what actually the Honorable has raised is actually one of the issues that really we need to direct our minds to. But what are we addressing? We are addressing a very, very serious problem which actually can create chaos in the country. Especially Article 52 in the current constitution is actually a very serious matter that requires the attention of this House of Parliament.
Chair, just to echo to say that a constitution it can never be perfect in one instance. That's why constitutional amendments, it's an ongoing process. We cannot put everything together, and even if we put everything together now, they will still have to be unbundled with time, because changes will still arise. And it follows therefore that we address the issues that are so more like prominent at each and every time that comes. Thank you.
Honourable members, do we still have questions? think their submission was clear. Yeah, yeah. Thank you so much, our witness. We lift your immunity. If you have any issues, you can submit through our clerks. Thank you.
Well, there you have it. The National Institute of Public Administration School of Law has made a submission before the Parliamentary Select Committee appointed to scrutinize the Consortium of Zambia Amendment Bill, National Assembly Bill No. 7 of 2025. And still to make a submission before the committee is the Common Grounds Network. Keep watching Parliament Television.
Watch the Parliamentary Select Committee that is scrutinizing the Constitution of Zambia Amendment Bill No. 7 of 2025 live on Parliament Television and radio on Saturday 6th and 7th December 2025. Stay informed and engaged with the legislative process on Parliament Radio, DSTV Channel 272, GoTV Channel 28, Topstar Channel 5, National Assembly of Zambia Facebook and YouTube pages. Parliament Radio, Parliament TV, bringing Parliament closer to you.
Sometimes it's hard to fight. Some days I'm not alright.
The witness in their submissions, particularly to do with the nominations, members of parliament, the number of members of parliament that will be nominated to parliament by the president. I remember of heard saying there will be 10 from 8. In the proposed bill. Currently it's 8. If the elected members of parliament goes to 211, there's only an increase of 2 members from 8 to 10. Maybe I wanted to seek clarification. What is the basis in terms of calculations, so that I think we are made aware that indeed it will be 10. I submit.
Witness, you can proceed and respond to those 2 matters. Thank you.
Thank you, Chair. I will invite the Director to respond to the first question, and one of the team members will pick up the second.
Thank you, Chair. Chair, in terms of Honorable Nkombo's question, we did provide just some background information to the Ministry, but we also assisted Chair in simplifying the bill and translating it into local languages for information dissemination to enhance participation of the public and stakeholders in reviewing the proposed bill and in making comments. Thank you, Chair.
Thank you. You can proceed if you have.
Thank you, Chair. Just to clarify on the increase on the nominated members of Parliament, Chair, the percentage used there is 5% for calculations. Thank you.
All right, thank you, witness. Any other points of clarification? Witness, do you want to add?
No, Chair, that's fine. I thought that was directed to me, but...
It's been addressed.
Yes, thank you.
Honorable Banda.
Thank you, Chair. It's a straightforward question. You know, as a member of Parliament, I've been asked by people regarding the rationale that would be used in terms of appointing the 20 women that will be elected through the proportional vote, the youths and the disabled. So maybe I would want you to clarify as to what, as Zambia Law Development Agency understands as to how it will be done once this law is passed, because people have got different views. You know, I've been told things that my understanding is different, but people have said it different in a different way. So I would want to hear from you, so that even the public out there maybe may have a picture. Thank you, Chair.
Thank you. Honorable Manda.
Thank you, Chair. Mine is just a rider on Honorable Banda's question, just a very short question. When it comes to youth, there's usually all sorts of ages. There's some that say youth is between 18 to 35, and at times the youth can even go up to 45. So in your view, which is the correct age that should be used for youth, and should it be enshrined as well, or should it just be left open-ended as youth? I submit. Thank you.
Okay, I hope you are taking note, Honorable Sabah.
Mine is just a clarification. There was a question from Honorable Mungand on the percentage, and then his response was just 5%. I would beg if you, so you know, the people are watching us, so when you just say 5%, they will not know what you mean. So maybe you can amplify on the 5% issue. Yes.
Okay. Witness, you can proceed.
Thank you very much. The 5% is divided by the number of total MPs. That is when you arrive at the actual number of nominated MPs. Thank you.
Okay, I think you're opening now a Pandora's box. Honorable Mungandu.
Sir, I would like you to confirm. I would like you to confirm a Law Development Commission, because indeed you just said 5. Is it based a formula derived from the existing members of Parliament, where when you apply 5% of the existing members of Parliament is what gives you 8? Now if you apply the same formula of 5% on the proposed increase in a number of seats to 215, it will only give a maximum 211. It will give you a maximum only of 10. We wanted this to be very clear, so that we leave no speculation and no doubt that the nominated members of Parliament by the President under the proposed amendments will only be 10, not what is being speculated, so that we know. I submit, Chair.
Thank you. Witness, you can proceed.
Okay, thank you very much for that, Chair. The bill does say that 10 members will be nominated. So that is the basis upon which this is referred to. We have an increase that we noted again from the bill that talked about the percentages for gender thresholds, for example. So that is all stipulated in the bill. And we were basically translating that into our own submission as reflected. Then with regards the youth age, the age of youths, who constitutes youths, we have national documents like the national youth policy that defines what a youth is. we also look to our own constitution for key definitions, and all policies, all laws must align with a constitutional definition. So where the term is used, youth, we rely on the constitution to guide us on what should constitute that particular age. When it comes to the selection of how many women, how many persons with disabilities, I think this is part of the ambiguity of the provision, and one that we have critiqued, in that it is relegating this to legislation. So it has not given us a formula as to how these will be selected, what is the detail, and that's where the danger lies. In our submission, we are proposing that the Constitution must clearly state the procedure for selecting how many of these women, how will they be selected, from where will they be selected, and so on and so forth. That level of detail is missing in the proposed constitutional provision, and therefore our recommendation is that it must be entrenched the same way that South Africa, the same way that Kenya have given that level of detail. I submit, Chair.
Thank you very much, witness. I just have clarification on your submission on Article 103. I note you stated here that the amendment to Article 103 should not be supported in its current form. While it successfully clarifies the presidential petitions must be determined, not merely heard within 14 days, it undermines constitutional certainty by shifting all key procedural details to legislation. So which are these key procedural details to legislation? Because the current provision itself in the Constitution does not give any details of filing and all the other details. So maybe you could just clarify what you mean. You're saying that the Constitution should retain essential procedural elements such as filing deadlines, judicial oversight, and mechanisms. So currently, the current provision does not provide for that. So maybe you can clarify what you mean.
Thank you, Chair. I think, like I mentioned in our submission, we did look at provisions that best practices give as well. So we're not just looking at our own current constitutional provisions in making this recommendation, but recognizing the challenges that existed previously as a result of our current constitutional provision, that there are gaps, and one of the gaps is that we don't have the necessary detail, especially in terms of timeline, in terms of when the determination should happen, and to avoid these prolonged lacunas in having power replacements or transitioning of political leaders. And so bearing that in mind, we looked at comparative studies on Kenya and on Nigeria, United Kingdom, that do have these procedural safeguards, and it's on that basis that we're saying if this provision, progressive as it is, in allowing that the determination should happen within the period that's stipulated, it needs to go over and beyond that to give specific procedural safeguards for when all of this should happen. Once that is done, we enhance the constitutional provision, and that way we'll have a better constitution compared to what has been proposed in the current Article 103. I submit, Chair.
Okay, all right, do you have a follow-up?
Thank you. I think I'll take you to your recommendation on the repeal, and that's Article 58. No, it's Article 68. Article 68, repeal and replacement of Article 68, composition of National Assembly. On your recommendation, I'll read. The proposed amendment to Article 68 significantly increases the size and composition of the National Assembly, raising the number of constituency-based MPs from 156 to 211, a 35% increase, and introducing 35 new proportional representation seats, 20 for women, 12 youths, and 3 persons with it. It also raises nominated members of Parliament from 8 to 10. This is where my first question was based. Now I want to go further. If you go down, these bodies advocated for, meaning the Mwanakatwe, this is what your recommendation says. It sharply diverges from the recommendations of the Mwanakatwe Commission, the 2015 Electoral Reform Technical Committee, ERTC, and the Slungwe Technical Committee. These bodies advocated for a kept presidential nominations at 30% gender quotas and a parliamentary oversight. I want you to clarify what is being proposed from my own understanding and also for the benefit of citizens is to secure the seats for women. This is my understanding, where they will be able to just be appointed, remove the barriers, even the youths, for a youth to compete. My understanding is that it has been very difficult. They need resources, but this is the sure way, and the international practices within the Commonwealth jurisdictions. I think you've even given examples. Now, how does this again go against the advocated nominations at 30%? We should have done more, or something extra should be done. What is it that you meant here? I submit.
Thank you, Honorable Mngandu. Witness, you can respond.
Chair, just to clarify, what the honorable member is citing in the recommendation, Chair, is actually something that should have been sitting in our analysis. It is merely a comparison, honorable. If you read it, we are just comparing the number of seats that will come if this bill is enacted into law, and just in from what came out of the comes page, which speaks to operationalize the proportional representation system. I think the gist of this recommendation is that we do support the proportional representation system because it will enhance representation of previously disadvantaged groups. The caution from the Commission is that how this provision is going to be applied should be very clear, whether it is in the Constitution itself or in subsidiary legislation. Answering some of the questions you were asking earlier, how will the women be selected? How will the youths be selected? How will the persons with disabilities be selected and be identified? The recommendation of the Commission is that whether this will sit in the Constitution or in the Electoral Process Act or any other legislation, the provisions should be clear, so that all the players within the political sphere know how they will participate using this particular system. I hope we have managed to clarify that, Chair.
Thank you. I just also have a clarification on your submission on provincial ministers. You have submitted that the amendment should not be supported in its current form, while the 90 days resignation will promote electoral fairness. The total delegation of key government provisions to legislation undermines constitutional oversight to ensure accountability and consistency. So, considering that these provincial ministers are politicians who are participating in elections. What is the rationale of this submission to state that delegation undermines constitutional oversight? Maybe if you can explain what you mean. Should these ministers remain ministers while as campaign period, using government vehicles, government fuel? This is on 117, is it? No. Yeah, Article 117.
Okay, Chair, just for clarity, would you please repeat the question? What exactly?
Yes, my question is that on your submission, you are saying that the amendment to have provincial ministers resign 90 days before election should not be supported in its current form. While the 90-day resignation rule promotes electoral fairness, the total delegation of key governance provisions to legislation undermines constitutional oversight. So you are saying to ensure accountability and consistency, the Constitution must include clear guidelines on the roles and limits of provincial ministers, not to leave them to future laws. So my question is, what do you mean? Because these provincial ministers are members of Parliament. So Parliament is dissolved, or so to say, Parliament is not functional because a 3 months election campaign period. So what is the rationale of what you are saying, that the delegation undermines constitutional oversight? Do you still want minister? I don't understand what you're trying to. Maybe in clearer terms, what do you mean that this undermines constitutional oversight if they remain, if they stop executing their duties because there's an election? What do you mean that this undermines constitutional oversight?
Chair, we do recognize the importance of the provincial ministers vacating office to curb the use of public resources. I think that's the extent to which we agree with the proposal. Our concern is having to, what then happens in their vacancy to deal with some of the other things that are supposed to continue in operation. How will those be dealt with? Because the constitutional amendment does not speak to them. So the idea is, whilst we recognize the need to have ministers vacate office and to serve public resources, that provision can be enhanced if it takes into account some of the additional interventions that would have to be taken to ensure that government or governance does not come to a standstill as a result of the minister not being in office. So that's our recommendation in this regard. So on its own, it would be dangerous to just say let them vacate without giving guidance as to what happens thereafter. I submit, Minister. We actually did point to it under the recommendations that are listed in 13.5, the fourth one, in which we were recommending that the Constitution must also retain the 90-day resignation clause for ministers seeking to contest elections as currently proposed. However, this should be reinforced with enforceable restrictions on the use of state resources during campaigns, monitored by Electoral Commission of Zambia and the Auditor General to guard against indirect incumbency advantage. There is also the understanding that the minister might vacate office, but still has an influence over the people that they were working with, or access to resources in that regard. So it's not automatic that once we remove the provincial minister that there will not be any influences, or there wouldn't have been things that have been put in place that could amount to abuse of public resources. So what are the safeguards in this regard that we're putting in place to ensure that the protection of public resources still remains in the event that the minister vacates office? I submit, Chair.
Okay, I know it's a very interesting submission, because I'm thinking to myself that when Parliament is dissolved, there's no vacuum in legislation. There's no MP, it's dissolved. So you can't say that. Anyway, it's interesting. Honorable Chambers, give a
yes, just a simple clarification. I was thinking that in the absence of the provincial minister, just like the portfolio ministers, there is the administrative system, the PSCs and directors. Those are the people who run together under the instruction of the president. So what else would you think is missing, should be put there? Because the government system is a regulated system. So even if the minister or the provincial minister vacates, regulations are there. So this is the question that is coming. What else do you think should be done? And should the detail of what you are thinking be put in the Constitution? We are going to have a Constitution that's going to be regulating everything. I thought maybe those other regulations and administrative processes are well defined. Thank you, Chair.
Thank you, Honorable Nyambose. You can proceed, witness.
Thank you, Chair. Thank you, Honorable Member. I think that is noted. Again, our submission talks about alignment, delegation, and divergence, and I think that guides us in what is the acceptable percentage of what we should be relegating to ordinary legislation, what should we be keeping in the Constitution, and so on and so forth. And whilst we do recognize that not everything can go in the Constitution, we should also be cautious that we don't leave a vacuum, or we don't leave an assumption that because there are systems in place, those will be operational even in this particular case. We have given examples of the comparative study for Nigeria, for Kenya, and for South Africa on some of the interventions that they've put in place to ensure that public servants do not misuse state machinery for political gain. And all of them do recognize, in line with what we have agreed to, that there needs to be a vacancy of office, but the detail of which what happens in certain cases, in the case of South Africa, they have what is known as the members of the Executive Council, the MEX, who actually continue carrying out, I think, similar to your own recognition of systems that we have here. But this is explicitly stated that, within the Constitution, even if it's a cross-reference to legislation, we'll provide the detail for what happens in that case. That should be covered. If it's not covered, then it leaves a vacuum, or it leaves us to assume that there is provision that would cater for when the minister is not in office. I submit. I don't know if any of my other colleagues would like to add to that.
Yes, if there's if anyone else wants to add, they can proceed. Okay. Honorable members. Okay. Okay, Zambia Law Development Commission, thank you very much for appearing before the Parliamentary Select Committee appointed to scrutinize Constitutional Amendment Bill number 7. We are most grateful for your submission. And at this time we would like to lift the immunity that was bestowed on you, and allow you to be able to enjoy the greater immunity that you have outside there. You are on your own. Thank you very much. You are free to go, and thank you for your submission.
watching Parliament television, and that was the committee that has been selected to scrutinize the Constitution of the Republic of Zambia. That's the Amendment Bill, National Assembly Bill number 7 of 2025, and they were meeting the Zambia Law Development Commission as the commission made its submission to this select committee, which will be meeting throughout from starting today. Earlier on, they did interact with the Ministry of Justice, and that was in the morning, but we were unable to televise that due to the sitting of the House. So we'll continue bringing to you all the witnesses as they come to interact with this select committee and as they come to make their submissions. And this is just to remind all our viewers out there that Parliament Radio and Parliament Television will continue meeting, or rather revising the meetings tomorrow, which is the 6th, and Sunday 7th December 2025 rather. They continue making as the witnesses come to make submissions to the select committee. So these will be televised live on television, Parliament Television, and also Parliament Radio will carry out the meetings live as they meet. And so this meeting will continue until next week when they wind up the submissions. So this is next week, Friday 12th December 2025, when they have the last witnesses. We'll continue giving you the updates, and in the meantime, may I say that this select committee actually has been constituted, and this follows an announcement by the Honorable First Deputy Speaker